to reassure the voters that the money was going to be handled responsibly, that there were going to be a lot of financial assurances and financial protections, so that the voters, the bonds that the voters were approving would not end up being wasted. And that means, and these are mandatory provisions, there's no question, these were not you may or you should, these were requirements. When the authority didn't do those requirements, it did not follow through and do a mandatory act, an act that the law specifically enjoins. It's a violation under 1085, under Code of Civil Procedure 1085, and that's why a cause of action is appropriate, because the legislature has violated, the authority violated a mandatory duty. And that can be redressed by ordering a writ issue. Now the question is, what are the consequences of not doing that mandatory duty? According to the authority, they can just go on to the next step and ignore the fact that they didn't complete the mandatory duty. Well, what we argue is that there is a process, and that the subsection C funding plan was a part of that process. And when you skip that part of the process, you can't go on to the next part because it is a process. In essence, in the ballot measure itself and in the ballot materials, it talks about an updated funding plan. Well, you can't update a funding plan that doesn't exist. If the court determines that the subsection C funding plan is not adequate, doesn't satisfy the requirements, then it really needs to order a decision. If the C funding plan is being rescinded, there is no funding plan to update.
Why isn't that sufficient? Let's assume the court was to do that, simply to order rescission. Why wouldn't that be a sufficient remedy?
Well, in some ways it might be, in terms of essentially what we would end up then having to do is do a separate cause of action to say they're already violating the requirements of subsection D. But in fact, the fact that they haven't done the subsection C plan properly and are still going ahead and doing provisions, essentially committing funds in violation of subsection D, I think the court has a duty to act there and say, wait a second, you can't be going forward here. You haven't even completed step 1, and you're already going ahead as if you completed step 3.
But isn't there at least a question there with regard to the funds in terms of whether or not we're talking federal funds, whether or not we're talking section G funds? And isn't that part of the difficulty with that?
Not exactly, because even if you were to grant the authority's argument that they can use the ARRA funds on the President of Merced segment, which I don't think that's true, but nevertheless, even when one says that, if one says that, the total amount of those 2 grants plus the ancillary required money comes out to more than $2 billion. So essentially, by signing those 2 grants, those 2 contracts, the authority has said we're going to spend more than $2 billion. Okay, they have to match that with state money. And that means they're committing state money to match that. Now, it's not 100% match, but that $2 billion has to be matched with somewhere around $1 billion of state money. Well, if you take the subsection G and the subsection H monies, which are the only monies that can't be spent without doing the funding plan in subsection D, those 2 all put together is only $900 million. I say only $900 million. But nevertheless, that's what it is. It's $900 million. That means that the total amount that they can spend without going beyond the subsection G and H is roughly $1.8 billion. They're going beyond that. And consequently, the problem is that by going beyond that, they are essentially committing bond funds, not explicitly committing, but implicitly committing bond funds towards construction, towards subsection D provisions, because they've gone beyond G and H.
Or some other funds that has another issue associated
but
with that.
There aren't any other funds. And if they are going to commit funds that haven't been appropriated, that's a violation of the state constitution. You can't do that without first going to the voters. The only funds that they've gone to the voters for and gotten permission from the voters to do that for are the bond funds, and that's the only funds that are appropriate. So you're kind of left with this one pot of money. There is no other pot. They can't point to some other pot and say, we could use that. There is no other pot.
Ms. Enon, do you agree with Mr. Fleischman's calculus?
I do not agree with his calculus. The only approvals made by the authority are the 2 contracts that are discussed in the brief, the 2 Cabrini contracts and the CP1 contract. all future approvals that petitioner is talking about are in the future and have not been committed. Therefore, those cannot be considered commitments. If the court is going to consider future commitments as binding commitments now of the authority, then the entire project is going to violate the subdivision D funding plan requirement, because those are all going to be made in the future. The only commitments that are at issue are the commitments in the two contracts, and they are together about $1.2 billion, and the state share is roughly half of that. As I mentioned earlier, those contracts are being paid with federal funds. That's allowed under the Bond Act. Under the current ratios of federal and state spending, the state's behind, the feds have to catch up, and there is no matching required anytime soon.
Your Honor, I guess I have to beg to differ on some of the arguments that she's making in terms of saying that a commitment is not a commitment unless the money is actually going to be spent in the immediate future. I think the fact that the federal grant agreement requires a match and that they are spending money, and I have to say that the money that's involved here is well more than $1.2 billion, because that doesn't include, that's just the two contracts. That doesn't include the various land acquisition that's not included. That's a separate contract in terms of the purchase of land for the right-of-way. It doesn't include the utility relocations. Again, those are separate contracts outside of the Caltrans and the Tutor Perini Parsons contract. So there's additional money. When you take all of that together, it's well over the $1.2 billion. It's more like $2.1 billion.
What about the additional monies Mr. Fleshman's identifying?
No money has been committed for any of those purposes. No money's been committed for land acquisition. No money's been committed for utility relocations at all. The only committed contracts are the ones that were discussed in the state's opposition brief. So
would it be fair to say that money's simply been identified for prospective future activity?
Yes.
Your Honor, the fact of the matter is that the Tutor Perini contract and the Caltrans contract can't go forward until there's land to do it on. They're talking about breaking ground in early this next year. Where are they going to break ground if they haven't bought the land? If they need to relocate the utilities, that needs to happen first before they start doing construction. So if they're breaking ground, say in January or February of 2014, those other contracts, if they haven't been signed yet, they're going to have to be signed very soon. And in fact, the authority has been trumpeting the fact they've already opened an office to involve itself in the real estate acquisition. They've made deals already with people to buy their land. There's been articles in the newspaper about closing a restaurant because the authority is buying it and going to tear it down for the construction. So when they say there are no contracts, I have to say, well, how come these lands are being acquired if there are no contracts? Where's the money coming from that?
Ms. Zenon?
The authority, Your Honor, the petitioners have to show commitments of bond funds that violate the Bond Act. There are obviously going to be land purchases that are going to occur in the next year. But those are going to be paid with federal funds to the extent that bond funds are not available for use at that time. The important thing is that the only commitments now are comply with the Bond Act. They are not using bond funds because they can't use bond funds. And we can't be discussing future commitments because those have not been made. And we'll have to discuss whether those violate the Bond Act if and when they are made.
But I think Mr. Flashman's argument is that when you take into account the two contracts that we've been talking about, those total $1.2 billion. And then when you take into account additional expenditures that would be necessary in order to implement those two contracts, the $1.2 billion goes up.
That's correct, but the total amount of the grant is $3.4 billion.
And then we're talking about the matching funds and whether or not the matching funds then exceed the allowable amounts available to the state.
That may occur in the future, and at that time, a decision will have to be made. But those are decisions that are going to be made by the executive agencies of the state of California and that are not the subject of a writ. Right now, the authority is walking a fine line between moving this project along and complying with the Bond Act, and it is complying with the Bond Act requirements.
I guess, Mr. Flashman, isn't your argument one that's a better argument for a later day?
Well, Your Honor, the fact that they are basically saying there are no commitments. But if they are committing, let's say, $2.1 billion of ARA funds, then they are essentially also committing the matching funds for those ARA funds. And the matching funds for those ARA funds exceed what's allowable under G&H.
But won't that all boil down to when those commitments actually occur? You may ultimately get to the $2.1 billion number, but if you're not there yet, there doesn't seem to be a problem.
If they have already, in other words, if they have made commitments in terms of the two contracts and the requirements in order to go forward with those two contracts, because essentially, if you can't do the two contracts, well, if you're committing to the two contracts, it's you know, kind of like, I guess, goes back to maybe the argument I was making in terms of the C and D, which is that you can't put on your shoes until you get out of bed. And if they're saying we're going forward with these two contracts, and those two contracts require, before you go forward with this contract, you've got to buy the land, you've got to relocate the utilities. By committing to going forward with those two contracts, you've also committed to doing those other precondition things. Purchasing the land, relocating the utilities. You can't start doing construction until you've got the land to do it on. You can't start doing construction until you relocated the utilities that you'd be disdamaging if you went ahead with the construction without doing that. So they've committed to the whole package.
Well, I don't disagree with essentially the logic, but it is still somewhat anticipatory. What you're assuming is that, in fact, those things must occur. It's just like you can't drive on a roadway until the road exists. And I understand that, but the contract for the actual construction of the road hasn't yet been let, despite the fact that the contract for the purchase of the vehicle seems to have been let.
And I think the answer is that we're talking not just about expenditure, but commitment. So if you are basically saying, we're going to drive on this road, and we're going to do it next Tuesday, then you're committing, we're going to have the road finished by next Tuesday, because otherwise you can't commit to the time you're going to drive on it.
But isn't the lawsuit still a little bit premature, and wouldn't it be better to wait until such time as the actual contract is let, and then the numbers actually work in your favor?
Well, I think the answer is subsection D, which says that you can't do any commitments of bond funds until you've done the funding plan. And the purpose, obviously, is to say you don't start, you don't even start putting those, holding those funds aside and saying these funds are intended for this use, and we're basically promising these funds. You can't promise the funds until you've committed the funding plan. And they're promising the funds. They're spending the federal money, and the spending of that federal money is saying we're promising the funds. And there are no funds to promise other than the bond funds. So they are promising the bond funds, and they're committing them.
Ms. Eno?
May I respond? First of all, the fact that the state is going ahead with these two contracts doesn't mean that it has to do things in the order that the Petitioner's Council has suggested. Right now, those contractors are in design mode, and they are taking design planning from 50% to 100%, and that's all that's going to be occurring on those contracts for some time. So you don't have to have land purchased before you can consider whether the contracts themselves are commitments. That is not the case. Second of all, the state is going to approve and submit subdivision D funding plan when it needs bond funds to match. It does not need bond funds to match at this time under the funding strategy that it's been approved with its funding partner, the federal government. Therefore, there is no violation of the Bond Act. So those grants require matching. They do not require matching with bond funds. And they very carefully don't require that. They were both initially executed before the funding plan was even approved and are referenced in the funding plan. And they couldn't promise anything they didn't have.
Where's the money? If they're not using the grant funds, if they're not using the bond funds, what other funds are they using? What other funds can they promise the federal government that's going to be used to match? There aren't any. And to promise funds that don't exist, again, would be a violation of the state constitution.
Well, let me ask Ms. Zenon to respond to that.
Our grants, the two grants were executed with the expectation that there would be bond funds to match. They clearly indicate that. And the only debt that is prohibited by the California Constitution is debt that's compelled. These grant agreements don't compel any debt. All they do is obligate the state to match. The state, the case law that interprets the California constitutional provision has indicated that contingent liabilities and contingent debt are not debt within the meaning of the constitutional provision, and that's what exists here.
You've lost me. If it's an obligated, if it's an obligatory match, how is it contingent?
It's contingent because the expectation is that bond funds will be available to match. It's contingent because other state funds may not be necessary to match. There are a lot of options available to the state if it doesn't have bond funds available, including termination of the contract. It's contingent because the grant language itself makes the commitment to match contingent. If the court looks at the language on page 3 and page 38 and page 93, it's clear that if bond funds are not expected to be able to match, the authority shall make all reasonable efforts to secure another funding source. That is the funding arrangement that has been set up. Additionally, it's also contingent because there's no obligation to match now. As we stated in our opposition papers, the state has spent far more than the federal government has spent. We are in a catch-up mode against federal spending. Therefore, there is no match that's required, and there can be no violation of the constitutional requirement as a matter of law.
Your Honor, just because the authority hasn't actually spent the money doesn't mean it hasn't obligated that money. It signed the contracts. Those contracts obligate the state to follow through and pay the money for those contracts. So that federal money and the corresponding match of state money are now obligated under the contract. And if those contracts, which this is the argument we're making, is that those contracts, when you take together those contracts and, excuse me, and the ancillary spending that has to go along with
Grab some water. But be careful when you pour up your example.
Thank you. The combination of the money that is obligated under the grants and the money that is indirectly obligated, under the contracts, and the money that's indirectly obligated because it's required in order to go forward with those contracts, that whole package is what's been obligated at this point.
All right, I understand.
And under the grant agreements, that in turn means there's a state obligation to match. And while the authority may argue, well, there's a difference between an obligation and an obligation, I think an obligation is an obligation. And, to call it contingent is kind of hand-waving, because when they are required to match, I think that's an obligation. It may not be an obligation that has to be satisfied right now, but nevertheless, it is an obligation. Just the way as a contract is an obligation, it may not mean you've got to pay the money right now, but it is committing you to paying those money. These are commitments that have been made. And the commitment of matching funds is just as much commitment, even if the funds aren't actually required to be put up front and paid out for 5 years. Nevertheless, they have been obligated, they have been committed, and that's what's prohibited under subsection D.
Your Honor, the contracts contain, the Caltrans contract is an interagency agreement between two state agencies that can be canceled at any time. The Tudor-Perini contract has a 30-day cancellation provision in it. Therefore, those contracts only obligate payments to the extent that they are live contracts. And in the case of the Tudor-Perini contracts, the state is proceeding very carefully, giving the contractor very limited notices to proceed as we go along and as we resolve, so that the with validation of the bond and still allow this program to proceed. The contracts are for certain amounts of money. However, the state has been very careful to make sure that those contracts are canceled and rescinded if necessary. They do not commit the state to the entire amount of those contracts.
And if they have those clauses in them, how does that basically provide for an, in a sense, a permanent obligation? If the contracts can be canceled, isn't the obligation, as Ms. Zenon argues, a contingent one?
Just think about that.
I'll leave it as a rhetorical question for now.
Okay.
I think I understand the issues, unless council wanted to offer something else.
The one other thing that I think that we raised in our brief, and that I think that the court may wish to address is the question about what about moving forward and spending the federal money when the 526A action is still pending. And the issue is there that the federal money's expenditure is essentially to build the initial construction segment. If, in fact, the 526A action is successful and the court ends up concluding that the grant money cannot be spent on this project because it's not this project that the voters approved, then you've got roughly $3.2 billion of federal money that you're gone ahead and started spending, but you can't do anything useful with that $3.2 billion. You can't build even a segment that has independent utility. You can build, you can prepare a track bed for the eventual laying of tracks that aren't going to get laid, but that's not going to give you something that has any utility. It's essentially wasting all that money.
But isn't that a subsequent issue?